All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us here today for the second session of our Consumer and Disaster Law webinar series, Navigating Landlord-Tenant Law After a Disaster. Before I introduce our speakers, I do want to go through some quick housekeeping announcements. The training is being recorded, so you're going to receive a copy of this recording in an email from Zoom within 24 hours. If you don't see that email, I'm going to drop my email into the chat just in case. We're also going to be posting it on YouTube, so you're going to be able to find it on our YouTube channel as well. The training was approved by the Florida Bar for one general CLE credit and one real estate certification credit. I'll announce that CLE code towards the end of the session. I'll drop it into the chat. It will also be included in that email, and it will also be included in the YouTube description. Closed captions are enabled for anybody who needs them. If you have any issues with accessibility or the captions, just reach out to me directly. This training is being co-hosted in partnership with the Public Interest Law Section, PILS, and with the Disaster Umbrella Group, Doug, and with Legal Services of North Florida. That's nice. See, I can never get it right as much as I practice. So I encourage you to all to visit the website for PILS. I'm going to drop the link to the site. If you're a legal aid attorney and you're not familiar with the Disaster Umbrella Group, I'm also going to include information about how to join that group if you're a civil legal aid attorney. It's a really great group. They have a monthly meeting, great discussions. They have a listserv. So if you're a legal aid attorney, you should definitely be part of that group. Um, Final piece of housekeeping announcements is questions and answers. If you have any questions during the presentation, feel free to use the Q&A feature where you can post questions. You can also use the chat if it's easier for you. If for whatever reason we miss out on answering a question during the presentation, we'll do our best to address those questions towards the end. Now, I've been lucky enough to experience this presentation before, so it's going to be interactive. Be ready with your phones because you might have to scan some QR codes. If a menu shows up, maybe you can order some food or you're hungry, but that's not supposed to happen. And make sure your audio is working because I know there's always going to be some audio that's going to come out of these slides, so be ready for that. All right, so I'm going to go ahead and introduce our two amazing speakers today, Michelle Trunkett and Jeff Hittleman. Michelle Trunkett's journey with Frills began, or Florida Rural Legal Services. So, see, Frills began in '98 when she joined as a summer fellow. Over the years, she has demonstrated unwavering dedication and commitment to the organization's mission. Post-law school, Michelle continued her service at Frills as a staff attorney and later assumed the role of regional managing attorney for the Fort Myers office. With a career spanning over 22 years, Trunkett has predominantly practiced in the areas of housing and consumer law, showcasing a deep understanding of legal complexities in these domains. Her leadership is further evident as she serves as the Housing and Consumer Advocacy Workgroup Leader at Frills. So our next speaker is Jeff Hittleman, and Jeff is an attorney with the Senior Citizen Law Project at Coast to Coast Legal Aid of South Florida. He handles housing, consumer, and domestic violence cases for seniors. Jeff is also the lead attorney of the Jim Moran Foundation grant, which has helped prevent over 150 seniors from becoming homeless in the last 2 years. Prior to joining Coast to Coast Legal Aid of South Florida, Jeff was an assistant public defender in Broward County. He is a proud double Gator. Congrats on the championship, Jeff, having earned a Juris
Thank
Doctorate
you.
from the University of Florida in 2012 and Bachelor of Arts in Political Science from the University of Florida in 2009. Jeff interned with the Legal Aid Service of Broward County for 4 summers while in school. Jeff is originally from Sunrise and enjoys cheering for the Gators, traveling, and playing golf. So, without further ado, I'm going to pass it on to our amazing speakers, Michelle and Jeff. The floor is yours.
Good afternoon, adventurers. Welcome to the game of leasing, navigating landlord-tenant law. After a disaster, I'm excited to introduce our guides on this journey across the game board of housing law. Michelle Trunkett, Advocacy Director at Florida Rural Legal Services, and Jeff Hittleman, Supervising Attorney at Coast to Coast Legal Aid of South Florida. Together, we'll move through the twists and turns of disaster recovery and tenants' rights. Along the way, we'll tackle game spaces like preparation, termination of tenancy, repairs, security deposits, federally subsidized housing, and mobile home parks. Don't hesitate to roll the dice and ask questions. Thanks for joining us today. And with that, the board is yours.
Looks like we've landed on preparation. Hurricane Wilma struck South Florida in 2005. Our office got a direct hit. No power for weeks, limited phones and internet. Our roof was damaged. Water was leaking in. Our experience with that shaped how we prepare for disasters today. Michelle, you just experienced one of the last big storms that hit Florida, Ian. What was that like?
Yes, thank you. We did experience a lot of what you described. I work out of the Fort Myers office, so we had a direct hit from Hurricane Ian. We also lost our office. We didn't have an office for about 9 months. If I'm remembering correctly, we had generally speaking, in our area was out of power. Many of our employees didn't have water or power for many weeks after the hurricane hit. So a big challenge in talking about preparation was making sure that we had everything on hand to be able to function without having those utilities and abilities to make copies and to get that information out and how we're going to communicate with each other. So that was a lot of what we've learned from Hurricane Ian. I'm looking at our slide here. It looks like we maybe identified some of the major issues that we saw during that hurricane when we were working with clients. One of the things that we had complaints about from immediately after the storm was landlords coming into property without proper notice. So we will go into that in the slides, and we had a lot of issues with utilities and who was responsible for repairs and that type of thing. So those are things we're going to go into later on in the presentation.
Just like we're about to stock up on food and water for hurricane season, there are ideas how to prepare for housing issues after a disaster. We can cross-train staff. Michelle pointed out distributing printed materials. This is a standard email that would go out because, after a disaster, there'd be a lot of public benefits issues, but housing would be a top priority. And you're going to need all hands on deck. So having everyone with at least a basic understanding of housing issues, even the family law team ready to pitch in, is a great way to prepare. We can also identify high-risk areas. In our community, Broward County, mobile home parks, and we also have properties on the water. Michelle, we even have the federally subsidized senior building right on the Atlantic Ocean. It was a Coast Guard barracks back in the 60s. And we just know if there's a storm, they're going to have issues. We built a relationship with them. When there was a problem a few years ago, we were able to quickly communicate and organize to go out and help. For our tenants, of course, good practice, save an electronic copy of your lease, take those before pictures of your valuables, belongings, and document the condition that the property's in before the storm.
Oh, and one quick thing I forgot to mention. Jeff and Michelle have a very strict cell phone policy. They insist you have it out and ready to use. Just scan the QR code on the screen or head over to menti.com and enter the code 324-63048. We'll be using it throughout the session to answer a few questions together. In your community, which types of housing do you think are most at risk during a disaster?
Ooh, Michelle, a lot of mobile homes. Yeah. Yeah. Rural housing. I'm glad you mentioned that. And flood areas. That's a big issue for us in South Florida.
Absolutely.
In your community,
Let me ask you, Michelle, you just helped a lot of people in one of the last big storms that hit Florida. Did Florida's Landlord-Tenant Act give you exact yes or no definitive answers to every question tenants had?
Yeah, so after the hurricane hit, I knew that I'd be facing legal issues that I was not personally familiar with, and I would have a really large learning curve. But I thought that I was really safe with the landlord-tenant issues. I've been practicing in this area for longer than I care to remember, so I thought surely that part wouldn't be a problem. And as it turns out, I wasn't as ready as I thought it would be. And the thing was that when you have a storm of that magnitude that hits your area, the normal rules of law that you're used to applying in situations don't necessarily apply because they're not practical. They're not responsive to the issues that you're going to be seeing in your community. So yes, landlords have certain obligations to make repairs, but it's very hard to do that if there's no contractors available, if there's no materials available, if there's no
Yeah.
tarps available. Or yes, rent is due on the 1st and you have a grace period, but if the storm hits on the 28th, like Hurricane Ian did, and you have no internet, and we went without, we've really bad, even when we had our power restored, many of us didn't have internet. So if you're making your payments
Right.
through the portal, that makes it very difficult to make a timely payment. And there were just so many issues like that we would find ourselves saying, well, under normal circumstances, this is what I would tell you. But right now, given what's going on in our
Yeah.
community,
Not normal
we're kind of
circumstances.
playing by different rules right now. So that made it very hard for all of us who want to give our legal advice, found in statute and case law. And we just found that a lot of the questions that came to us were not found in those areas. And we really had to, use different standards when we were trying to help people struggle, at least initially, while things were really, you know, right after the storm where things were really bad.
We're going to go through the fundamentals of landlord-tenant law after a disaster. It's going to shape how we help. What is the tenant's goal? There's going to be a series of decisions for the tenant to make to decide what their goal is. The first of those decisions, should I stay or should I go? If we've landed on termination of tenancy. Michelle, let's talk about how a tenancy can be terminated by the landlord or the tenant.
So, to kind of put things into perspective as where we were and right before hurricane hit, and afterwards, obviously there was a lot of property damage that happened across our entire area. But we also had huge numbers of people who were displaced all at the same time. And so they were all looking for housing at the same time. It really affected everyone, whether they were homeowners, whether they were renters, whether they were affluent, whether they were low income people who suddenly found themselves without a job and because their place of business no longer existed. So this was really a problem that was across the board affected everyone. And so everyone was looking for replacement housing or temporary housing while their homes were being repaired and remodeled. And so to add to the influx of that and the housing issues was that we had this influx of people from outside the community, as you usually do, to come in and help with repairs and recovery. And so what we found is that we had no available places for people to go to. And that made a situation in our area, and I'm sure it happens in other areas, where landlords who did have livable housing, those were now a premium. And so we experienced a lot of people who, or we spoke with a lot of people who had received termination notice from the landlord, people who might have been living there for a long time but never had a lease, but now this was the landlord's opportunity to get better rents, higher rent, or maybe there was damage, legitimate damage, and this was their opportunity to um, fix up the house so they can get higher rents in the market that we had in 2022, which was an extremely high rent time. And so we saw a lot. This was something that was experienced by many of our clients. And when people were coming to us, they wanted to know what their rights are. So I'm going to talk a little bit about landlords' rights to terminate, and then we'll talk about tenants, and then kind of parse through those a little bit. So first, when we're talking about tenants who don't have a lease, we're going to look at 8357 Florida statute, which.
Hey, Jeff and Michelle, quick question. After a disaster, can a landlord just boot a tenant out on the spot, or do they actually have to give them written notice first to terminate their tenancy?
Oh, good question. Very good question. And as Michelle mentioned, the answer to that is the landlord does, especially in a month-to-month tenancy. The landlord has to give written notice. And 8357 is going to explain how much.
I'm trying to recover from that. Okay. So chapter 8357 sets specific notice requirements when either the landlord or the tenant want to end a lease that doesn't have a fixed end date, like a month-to-month or a week-to-week rental. The required notice is going to be based on the periodic rental period. So as you can see there, if it's a year-to-year tenancy, it's going to be 60 days notice. If it's going to be if it's a quarter-to-quarter lease, 30 days notice. The most common type of monthly periodic payment is going to be done monthly. So landlords, as of July 1st, 2023, are required to give 30 days written notice prior to the end of any monthly period. This notice requirement applies to both tenants and landlords if they want to end an oral lease agreement.
It looks like someone we know just got a notice of termination of month-to-month tenancy. Let's take a look at it, see if there's any way we can help them out. One thing we can do is look for defects in the notice. There's a defect in the notice, that can become a defense for the eviction case. Michelle, let's go through and see if we can help out our friend here. Oh, I think this must mean there's another interactive poll.
What error or defect do we see in this notice?
Doesn't give 30 days, less than 30 days. Oh, I didn't think of that. Full name of the tenant is not listed. Clever one. And this sounds like we're shaping up a good defense.
What error or defect do we?
Thank you for sharing.
What error or defect?
Our team is on it. And they got it exactly right. Didn't give 30 days notice. This is a common issue. I think it's because of Google. So as Michelle said, this rule, 30 days, just changed a couple of years ago. But if you Google Florida sample notice of termination, month-to-month tenancy, all the old ones with the old number are going to pop up. And pro se landlords are using those old forms that they Google. So this is a good one to issue spot, make sure our tenants are getting proper notice and good defense for an eviction case. After a storm, curious about your experience, Michelle, but we saw a lot of times where, say, the landlord's family, their home got damaged, they came by and said, we need to get out I'm moving my family in here. You just need to get out now. Tenants have a right to the court process. The only way they can be removed in Florida is for the landlord to file an eviction case in county court and go through the court process of an eviction. Self-help evictions, where the landlord changes the locks, cuts off the power, those are prohibited. There's actually major penalties if a landlord tries to force a tenant out that way.
True or false?
Ooh,
If a
let's
rental
see.
unit is uninhabitable after a disaster, the landlord automatically has the right to break the lease without notice.
We don't know the answer to this one yet. We just wanted to get some guesses. See everyone guesses here. We have a unanimous false, Michelle. Our team, our landlord-tenant team is on point today. 15 false.
True or false?
Excellent.
True or false?
Michelle, let's talk about why that's the case.
Okay, so it's a little bit, there's a few parts of the statute that delve into when a landlord or a tenant has a right to terminate. So we're going to look at both sides. When we're looking at the tenant's right, the first section we're going to look at is the casualty damage provision in 8363. I think he's got it right here on the screen. You can see that this provision allows a tenant to terminate a rental agreement if the premises are damaged, destroyed, other than by wrongful or neglectful acts of the tenant, so that the enjoyment of the premises is substantially impaired. So we use this, or we advised about this section a lot based on when housing was damaged directly by the storm, directly after the storm, because there wasn't a house to go back to, or it wasn't a livable house to go back to. And so we would recommend that our clients would send a notice to the landlord under this provision of the statute, or the section of the statute, to terminate due to casualty damage. The second part of the statute, though, is a little bit different. It comes about when part of the premises has been rendered unusable. We didn't see this too much because, quite frankly, in our area, and I think that many people do experience this during our disasters here, is that a lot of the damage is caused by flooding. And so flooding tends to equally affect the entire property. But we did have clients who had experienced trees falling into the roof and maybe rendered one room untenable or unusable. We had some clients who the windows had broken and couldn't use certain rooms, or, believe it or not, we had people who didn't have siding anymore left on their house, and so they couldn't go in a certain room. So so we we would turn to this provision, and if in the rare chance that the rest of the house could be used, we could turn onto this provision of the statute. The problem is that it doesn't really state how you're going to determine what the fair rental value of the premises is, or if you and your landlord can't come to an agreement about that. So there is some ambiguity on how to properly apply this, if you're even able to reach your landlord. So, again, there's a statute there that provides a remedy, but it's not clear how to use it all the time, and it wasn't always very easy for us to instruct clients on how to handle these situations. I should, I wanted to go on to say that if you go back to the statute, Jeff, I'm so sorry, if you could go back, that first sentence, where it talks about, in the second line, the right to terminate based on casualty damage is limited to that of the tenants. If you can see it right there in the statute.
Mm-hmm.
So actually it's the third line. The tenant may terminate the rental agreement and immediately vacate the premises. So it should be noted that this right is given to the tenant, not to the landlord. And so that can become an issue for, a lot of landlords don't realize that or think that, particularly when lease
Mm-hmm.
agreements have provisions, and there were a lot of lease agreements that said that a landlord could unilaterally terminate a lease or a tenancy due to this type of damage. Um, so the right belongs to the tenant, not to the landlord under the casualty damage section. The landlords do not have the right to kick the tenant out in order to make repairs, which I will say this conflicts a little bit with another slide that we have. They can ask the tenant to leave temporarily if it's
That's the
essential
key.
to make
Temporarily.
but yes, to end the tenancy, that right's not given to the landlord in this section. And the landlords can't put language in the lease to waive that right under 8363. Now, there are some parts of the statute that might make this interpretation a little trickier, but we'll be getting to that too. So there is
Not a lot of case. Yeah.
yeah, I'm sorry.
Not a lot of case law on this issue, right, Michelle?
There's not a lot of case law on any of these issues, if I'm being honest. But we do have this Baldo case out of Dade County. I'm not going to try to say that next name in that citation. But here the court agreed that the right to terminate the tenancy for casualty damage is given to the tenant, not to the landlord.
Which brings us to if our tenant makes the decision that they're going to stay, they're choosing not to go, and the landlord's obligation to maintain the property and start making repairs kicks in, which brings us to repairs.
Yeah, so this gets a little more tricky, at least initially. And the way I see it in my head, there's stages of this. There's that initial damage and that initial decision that the landlord or the tenant has to make under the casualty damage section. And then it moves a little bit more to the tenant has decided to stay, and then maybe the damages get worse, or maybe it wasn't known, or they didn't realize that it was not going to be livable. Keep in mind that the standard for what's considered livable after a hurricane is probably not the same standard we use in good times or in blue skies, because when you have nowhere else to go, you're willing to live with something that you probably wouldn't have lived in. So we worked with people who didn't have water for extended period of time because there was nothing better available for them without having to leave the area. So people might not have taken up that right that came under that casualty damage provision because they simply couldn't. If they gave up that tenancy, even though we in normal times would say that house is not livable, they might have stayed. So at some point though, then people are starting to come to us because now they've lived there, they've tried to make it through, but it's just not working, for whatever reason. And maybe just because time has gone by and it's become too much for them. So in those situations, there are a couple places in Chapter 83 that will come into play. I'm going to start with 8356, which talks about terminations. Here, if they've stayed in the unit, but now they're ready to make, either they're ready for the repair or they need to vacate at a later time. 8356 subsection 1A lays out the process available to tenants if the landlord has materially failed to comply with the maintenance requirements. The maintenance requirements, I'm not going to go into too much detail here, are going to be found in 8351. They basically say that the tenant or the landlord is responsible for maintaining the building codes and the exterior structure of the house to make sure that it's functioning. So if the landlord is not able to comply with the material requirements of 8351, the tenant has two options, and you'll see that they're very similar to the casualty damage section. So in my mind, I differentiate this is not right after the storm. This is a little bit down the road, but I'm sure that's open to interpretation. So the section offers three options. The tenant can either issue a 7-day notice of intent to terminate based on the fact that the property hasn't been maintained. So it is a little bit different. It does require 7 days notice, and then there's going to be the question of liability for the rent through until after that 7th day. The third options contemplating the desire or the willingness of the landlord to make reasonable efforts to make repairs, but they're not able to do that due to circumstances beyond their own. So I think that's very common. I mean, I think there were very many well-intended landlords who wanted to make repairs after the storm, but simply couldn't because of limitation of contractors, limitation of materials. And so their desire to make those repairs was definitely not in accordance with the timeline that they had likely anticipated when they first, after the storm happens. So if the tenancy is not livable, then the tenant may vacate the unit for the time period that it's not livable, and they may abate rent for that period. So so that gives the tenant the right to move out until the landlord is able to make repairs, and hopefully there's still some time remaining on that lease agreement for them to move out. I think that the worse the storm is, some of these just not available, because if you had 3 months left on your lease, it might not be likely that your landlord is going to be able to make that repair in that 3-month period. If the house isn't completely unlivable and the tenant decides to remain in the property, then similar to that casualty damage provision, the parties can reduce that rent by an amount that's proportional to the loss of the rental value that is related to the damage or the non-repair. So it should be noted that 8356 subsection 1 states that if the material failure to make the repair is beyond the control of the landlord, and that the landlord makes every reasonable effort to correct the failures, the rental agreement may be terminated or altered by the parties. And I would say that language kind of brings into question the ability of a landlord to terminate the lease under that lease agreement that gives them that right.
Yeah.
I don't know that that's settled. I think that arguments could be made both ways, but I do think that calls that issue into question. And then finally, the section about another section of the statute that talks about repairs is going to be found in 8360. It is the process laid out under regular times, and then for repairs where the landlord's not making a repair, it's actually not it's not a way to force a landlord to make repairs. It's by far a perfect remedy for tenants, but it does allow a tenant to withhold their rent until repairs are made. So they have to issue a notice, a 7-day notice, inform the landlord of the tenants of the repairs that are needed, and they should be material repairs, and inform the landlord that they're not going to pay rent, or they're going to withhold rent until the repair is made. It's not an abatement. We're very careful to tell clients not to go and spend their money or their rent money. Then they need to be saving it, and when the repair is made, if made, they would need to pay that to the landlord. A couple things to keep in mind with this process is that this option will not be let me say this. Issuing that notice of intent to withhold rent doesn't have any effect on forcing the landlord to make the repair. All it really does is serves as a defense if the landlord then turns around and files a motion, an eviction for non-payment of rent. So essentially, you're just building up a defense for non-payment of rent eviction, but it doesn't really have the ability to force a landlord to do anything more. It also doesn't work if you're already behind in your rent when you issue that notice. I think it's very common for tenants to realize they're behind in their rent for whatever reason and just kind of start looking around and trying to figure out why they shouldn't have had to pay rent in the first place. And so and they're looking really how to shift that responsibility for the non-payment of rent to the landlord. So that notice doesn't work if the tenant is already behind in their rent. That can be really tricky in an eviction in a hurricane time, though, because again, if you hadn't been able to pay your rent because there was no power and you couldn't go onto a portal, these timelines become a little bit tricky. The other thing is it has to be issued in writing. And if they're issuing it by mail, they might need to keep in mind the requirement to allow for extra time for mail delivery. So Jeff has attached a sample notice to the tenant. I think this is a great form. You can be given to tenants,
Yeah.
and they can just check off the issues, and it's going to serve the purpose of that rent withholding letter.
Yes, and the Florida Bar has a collection of landlord-tenant forms. And one of the forms on the Florida Bar website is that repair demand letter. Good resource, good place to start. Now, Michelle, my landlord came by. I pointed out to him all the repairs that need to be made. We had a good conversation about it. Do I actually have to send him this paper letter? I mean, we talked about it already.
Yes. Yes, and in this case is a great case because it says just as a landlord's required to issue the 3-day notice to commence an eviction, the tenant needs to do the same to be able to utilize that notice as a defense. So absolutely, it's required in writing. I will say that I'm always, especially right now, I'm very cautious about recommending rent withholding letters to my clients because, like I said, this is offering them an absolute defense to an eviction. But that's the risk as well, is that the landlord then could file the eviction. And quite frankly, nowadays, an eviction, win or lose, the outcome of the case, can be far more harmful to a tenant, particularly in a community where there's limited housing. And having that eviction on their rental history can be very damaging. So while this is the process that's offered to tenants and available, just recognize it for what it is. It's not perfect, and the tenant should, be aware that, to fully utilize this process, it might risk them having that eviction filed against them.
Sorry to interrupt again. I know I said we'd save questions for the end, but just hypothetically, asking for a friend, can a landlord make you move out temporarily while they're doing repairs?
These are some of the most frequently asked questions regarding repairs. Michelle?
Yes, and I'm sorry I stole the thunder there. I answered this one a little earlier. I apologize. Yes, a landlord might be able to ask someone to vacate if it's necessary to make the repairs. The other questions I'm looking at here, if my lease is terminated because of damage, must my landlord provide me with other housing or pay my hotel bill? No, I'm not familiar with any requirement for a landlord to do that. What happens if my rent is abated? It's going to be the typical way to handle that is it's going to be prorated based on the number of days that you're not able to be in your unit. And then how long will the repairs take? Yeah, I think you wrote here reality. No one really knows after a storm, depending on how bad a storm is and how much the area is affected. I mean, it's been two and a half
After Ian,
years
that
and
was a
hours, and
challenge,
we still
right?
see blue
Yeah.
tarps. Yeah, so, yeah, it's roof repairs took the longest. I'm sure everyone who's gone through a hurricane can, shares that memory. But so if that's the impact to your house, it could take a long time.
As part of the repair process, landlords have the right to access the unit. The tenant should not unreasonably stop the landlord from coming in to make repairs. The landlord should give the tenant 24 hours notice, a day's notice that they're going to be coming in to inspect, start fixing things. Same goes for the landlord. They should not be abusing this right to harass the tenant. It really should be about making the repairs. For our low-income tenants, living check to check, getting their security deposit back, they count on that. I'm going to talk about the rules and then some strategy. Tenants should always take pictures and video to show the condition of the unit and even to show that the damage was caused by the disaster, not them. I just got a video from a lady. It starts zoomed in on the newspaper. She wanted proof of the date it was taken. I thought was clever. The tenant also has to give the landlord their new mailing address. If the landlord's going to return the entire security deposit, they have 15 days from the day the tenant moves out. If the landlord is going to make a claim and try to deduct some money from the deposit, then they have 30 days, have to send the tenant a letter by certified mail, say how much they intend to keep, explain the reasons for why they're deducting from the deposit. At that point, the tenant has 15 days to write back and object. If we reach that point, and 3 tips are try to negotiate. That's probably the best way. See if we can strike a deal with the landlord on how much to return. That's going to be the quickest way to get money back in the tenant's hands, money they're going to need to move to their new place. Those negotiations don't work. Tenants do have the right to file a lawsuit in small claims court for the return of their security deposit. A lot of clerk's offices have forms like this one. They're usually just 1 page, fill in the blank. Tenant can go down to the courthouse, fill them out, and start a security deposit lawsuit. But I imagine this was true after Ian, Michelle. The time and effort and the challenges in getting down to the courthouse, filing a lawsuit after a disaster, we're going to weigh those against trying to just strike a deal and resolve it much quicker.
Okay, so I'm going to talk about personal property. We put this into the presentation because we were quite surprised about how much this issue came up after Hurricane Ian. What we found is that people, their experience was that they had to be away from their property after the storm. They had to wait for the water to recede. Many of them weren't even allowed to come back. And so maybe they had evacuated out of state. Maybe they had gone to a shelter. But whatever period they were gone, when they came back, it seemed that the landlords in many cases had beat them back to the property. And part of that experience was that the landlords had gone in and as a way to protect the property had removed everything, the dry walls up to the certain, the watermark place and also all their personal property. And what we found, our experiences with our clients was that this was like really traumatic for them. It was enough that they went through the hurricane, that they, lost possibly their housing, but they were really angry and hurt by the fact that the landlords had removed their personal property. And, and so I just want to say that, if you're going to work with tenants after a disaster, this might be something you're going to have to be prepared to talk about. It was, unfortunately, there wasn't much we could tell them. I mean, they could, if they didn't have renter's insurance, then, they're going to be personally responsible for their own property. And there's no requirement for the landlord to insure the tenant's property. But in terms of the landlord removing their property, I mean, their recourse, if it wasn't done properly, is that they could sue in small claims court. But, how do you value property that was soaking wet and had been sitting in flooded water for, days? A lot of the items that they were really upset about were their pictures. So I'm not sure how you could put a value on those.
Yeah.
And likely, and maybe people would disagree with me, the landlords were within their right to at least take care of issues that would cause continued damage to the property. So in some cases, keeping certain things in the home might have been, at least I think there's an argument that might have been necessary to protect their housing. And so I'm not, I don't know, this is by no means my area of expertise. It's just something that we dealt with a lot. And so we had to talk to clients about.
Personal property,
What's
it's a
that?
tough one. Yeah,
Yes.
yeah, personal property is a tough one after
Yeah.
a disaster. I think the renter's insurance that you mentioned, usually like 10, 15 bucks a month.
Yep.
That is an option. And FEMA, tenants can try to make a FEMA claim for lost personal property. That's worth trying too.
Yeah.
Michelle, how about if there's an abandonment issue? How does that play out?
Yeah, and again, this is where the normal rules might not apply, right? Because under Chapter 83, a landlord can presume a tenant to have abandoned the property if they're absent for more than half the rental period, and if they haven't paid rent. If they paid rent, then the presumption is void. So here we had a hurricane again that happened on the 28th. You know, people maybe didn't have the ability to pay their rent through the portal. So there was some issues about abandonment. I would say, and what we told people is, try your best to be in contact with the landlord. Let them know that you haven't abandoned. Let them know that you plan to come back. Call a neighbor if you're out of town and you're not able to. But you really want to keep this abandonment issue, this abandonment concern, taken care of if you can avoid it.
Communication is key there. Yeah.
Exactly. Really, communication is the key to most of the problems that come about if you can reach the party. There is an abandoned personal property statute 715-104 that gives the criteria for the written notice that the landlord should give if they have abandoned and they've left property. This might come into play, depending on the type of damage that was done. There might still be property left that's, not completely ruined by floodwaters. So here is the requirements are outlined. The notice must describe the property, state where the property can be claimed, give a deadline to claim it, and inform the person of that reasonable storage costs might be charged. Must be hand delivered or mailed to the last known address.
That brings us to federally subsidized housing. First step is to identify the federally subsidized housing in your community. Good resource for that is the Schimberg Center through the University of Florida. If you go to the Schimberg Center, you can click on your area, and then a whole list of all the subsidized housing near you is going to come up by name, address. It's going to identify which federally subsidized housing program it is, we can figure out which rules apply.
Wait a minute. Did I hear that right? The Schimberg Center is part of the University of Florida? You mean the same school that just won the national championship in basketball? Go Gators and go housing data.
You're making it very hard for me, who's a Knoll, to continue to not say anything. Kidding. Okay, so we're going to talk, we're going to do an overview. Wait, we could do a whole session on subsidized housing rights and post-disaster. So we're just really highlighting things that might come up that you might want to be mindful of. So if there's a housing choice voucher, portability might be an option. Not always the best option if someone doesn't want to leave town, but that's an option. If the sometimes disaster vouchers become available, so that might be another option. Depending on if it's again a housing choice voucher or another subsidized housing program, that there might be the ability to ask for an inspection, to have and one of the housing authority inspectors come out to do a review of the property and what repairs are needed. And there might be potential for rent adjustments based on either change of income or depending on the housing quality issues. And he's just got some forms here showing kind of some of the okay. Then we're just going to go into some housing assistance programs. I'm not going to say I'm an expert in these. We have lawyers in our program who have become experts in this area, but I just wanted to touch on them so that you all might know what services might or what resources might be available. I will say that from my experience, much of this was not available directly after the storm hit, and resources came along down the road. So but they're out there, and if you are working with clients, you might be able to lead them into the right direction. So you've got FEMA rental assistance that can pay temporary rent payments, some security deposits or utility hookups, and relocation costs. And then you might there's FEMA transitional shelter assistance for individuals whose homes are unlivable or who can't find other housing, where FEMA is going to pay participating hotels and motels directly for temporary stays. And these are intended to be short-term, although they do sometimes get extended. But that's going to be limited based on available hotels in your area. And I know that there was a real shortage of hotels available in our area after Hurricane Ian. Then there's disaster housing assistance program, which has to be specifically authorized by Congress. Again, it doesn't come right after the hurricane, but likely it is available down the road, administered by HUD, and allows assistance to low-income renters already in HUD assisted housing. Then we in our area we received CDBG disaster recovery grants, which allowed the county to administer rental assistance amongst other things. There were funds for construction of new rentals, rehabilitate damaged rentals, and then the most important thing to our clients particularly was the rental assistance programs. And then you look to the local community programs. Our area, Red Cross, had some rental assistance programs that we were able to connect people with. Then you've got Catholic Charity, Salvation Army, United Way. I would always recommend contacting, if someone needs rental assistance, contacting United Way 211, because they are usually going to be the resource that has the knowledge of what resources are available in the area, and they keep, because that changes as time goes on. And so usually the United Way 211 has that most updated information. And then I'll turn it to you.
Mobile home parks were We're going to talk about mobile home parks last, but everyone answered they are first in line when it comes to risk during a disaster. Who's responsible for cleaning up a mobile home park after a disaster? The park is going to be responsible for cleaning up debris in the common areas. And then the mobile homeowner is going to be responsible for their lot. Utility shed, parts, furniture, mobile homeowner is responsible for their actual lot. What happens if the park is severely damaged and park management decides they're going to close it down? The rule is all the mobile homeowners have to get a 6-month notice prior to the park closing. This is a good area to issue spot because we've seen some parks that felt like 6 months was too long and they try to do it faster than that. This is a good area to issue spot. Make sure all of our mobile homeowners are getting their full 6-month notice so that they have time to plan what they're going to do next. Park residents also can apply to Florida's Mobile Home Relocation Corporation, and they may get some financial assistance. I think it's based on the size of their trailer. They can get money to help relocate. Michelle, our team, we navigated through the disaster. And we've reached the recovery phase. Thank you, everyone, for joining us on this journey.
Right. So if anybody has any questions, I don't see any posted on the Q&A. This is a good time to do it. I did post a link to a materials folder where you're going to find a copy of the slides. It's right here in the chat. It will also be included in the email that I send out. As Jeff and Michelle were talking, I was adding in those materials, there's a running document that I've been adding some links to some of these materials that they had mentioned. In the folder, I also added the disaster legal assistance manual that's updated every now and then for legal aid attorneys. Anybody can access it, particularly if you're going to volunteer. So the CLE code, I'm going to read it out loud. It is 2502269N. So it's already in the chat. It will go out via email as well. Let's see, I don't see any other questions. So I'm gonna go ahead and let me pull up my notes to make sure there's nothing else that I'm missing because there's a few plugs that I need to add. Let's see. Okay, so first of all, thank you everybody for joining us. I had already experienced a version of this presentation, but AI Jorge was not a part of it. That was awesome, by the way. Every time Jeff and Michelle present, they always come up with something really creative. I love the way that you make it interactive. So with that said, I wanted to thank everybody again for joining. Thank you again, Michelle and Jeff. Now, this is not the last session of this training series. We have the next session coming up in 2 weeks. We're gonna have folks from the AG's office present. So I will include links to how to register for that next session. If you haven't, you probably already received an email from me, but I'll make sure to include that link and instructions in the follow-up email. If you missed the first session, which was on foreclosures and homeownership, that one is already posted on YouTube, so I will make sure you have access to that link as well. So we're talking in disasters. It's April, so the idea with all of this is to be ready to go in case a disaster happens. It's always better to be prepared. I also want to plug in a quick warning about some bills that are pending it's possible that they will pass, that they will impact the way that we handle landlord-tenant disaster work. There is a flooding disclosure bill that could require landlords and mobile home parks and condo developers to disclose past floods. We already have a similar bill that's in effect for real property. Now, if you want to guess this bill, if it passes, it goes into effect on October 1st. So it's something to keep in mind. You know, it's going to impact clients moving forward if it passes. And the other one would be there's an emo notice bill that could also impact the way we address clients. Now, one thing I can promise is if these bills pass, we will have a training on it. So We will be ready to go. The idea is to have a webinar ready to go, so you have the everything that you need. If you're not a legal aid attorney and you're here in the audience, make sure to access all of these resources that I will be sharing. Be in contact with your local legal aids. If you're not sure, you're going to have my email. Connect with me and I'll connect you with the proper resource. I'm lucky to be connected with legal aids across the state, so I'm always happy to connect you. And I know legal aids are amazing with collaborating, whether if we were here in South Florida, I know the Central Florida legal aids and the North Florida legal aids are going to step up and vice versa. It's always great to see that level of collaboration. So when it comes to disaster, it's a great volunteer opportunity. So that's kind of my pitch for all of those attorneys out there that want to volunteer. So this is a great way to give back. So with that said, I think that was my last plug. I don't see any other questions. I do see a lot of thank yous for Jeff and Michelle. It was great meeting AI Jorge here for the first time, which, by the way, funny note here, real Jorge actually congratulated Jeff on the Gators win. And it turns out that AI Jorge also congratulated Jeff on the Gators win. So Jeff knows me well. Great job with the AI. So with that said,
Thank
we're
you.
past 1 minute. Any closing statements, Jeff and Michelle?
Thank you so much, everyone.
I just want to rightfully give credit to Jeff on the presentation artwork. He did a great job.
All right. Thank you, everybody. Have a great rest of your day.
Have a good one.